I got a letter from an agent today, and this is what the letter said. I can't believe we're back to doing this again, but my seller has agreed to make some repairs to the home. Side note, I have been having to change my approach to listing consults to help sellers understand the changing market and that they may have to make some repairs to get a deal done. I think that's really interesting because that really wasn't the state of things up until the last few months. So the fact that listing agents, when they first meet with a seller of a home, they're having to explain to them, it's not like it was. You very well may be hit with some repair requests, and you might have to do some of them, rather than just saying, well, if you don't want the house, guess what? Somebody else is in line, and I've got a backup offer already, and they don't want any repairs. That's not the case anymore. In fact, just in my office in the last month, we have been trying to help some people navigate a dispute over whether pool repairs are going to get done. The parties agreed that these very expensive, think to the tune of $50,000 plus, repairs were needed to the pool. They identified the contractor, and they set aside some money for the repairs to be done. But now the parties can't agree on releasing the funds to the contractor for the repairs. That's just an example of one of the many situations I'm seeing, repair disputes. As you know, minor disputes over repairs can quickly become major issues, and if you don't want to be caught in the middle of disputes like this, the best thing to do is to make a plan. So that means find out what needs to be fixed, who's paying for it, and when will they be paying for those repairs. In the contract, in section 4D, this says that the buyer acknowledges and understands that unless the parties agree otherwise, the property is being sold in its current condition. Seller may, but is not required to, engage in negotiations for repairs or improvements to the property. So what this is saying is that the default is property is sold as is. One of the realities of home ownership is that repairs to the home are inevitable. But when you discover during your due diligence period as a buyer that there are repairs being needed right then and there, who's going to pay for them and how? There's a few different options for this. Let's talk through the pros and cons, the pitfalls, and some situations that you really may not want to get caught up in. All right, the first option is you default to what the contract says. What is our baseline? It is that the property is being sold as is. Now, something interesting here is that if what you discover as a buyer is something that would be a material fact, and let's say the seller doesn't know that there's some structural defect, but your inspection reveals it, and the seller says, well, I'm not fixing it. If the seller goes under contract again, they know about this issue now, so it becomes a material fact that they have to disclose to future buyers. I am not telling you how to negotiate your deals. I have seen many, many times, though, that whenever something that's discovered that's a material fact, that a buyer will say, well, you're going to have to disclose this to a future buyer anyway. Can we work together to try to figure something out? Because now this is becoming an issue when you put the house back on the market if you don't want to sell to me. So that's the first option, buy as is, but just keeping in mind that if your inspection reveals a material fact, then that may give you some more room to talk to the seller about pursuing other paths. The next option is that if the seller agrees to make some repairs, or they acknowledge that repairs are necessary, but they decide they will not be physically making the repairs themselves, they could give a lump sum to the buyer at closing. At closing, not before closing. The seller cannot write the buyer a check and just slide them a check either before the closing or at the closing across the table. This all has to be accounted for on the closing statement. So there are two common ways to do this. One is a reduction in purchase price to account for whatever the amount is that the seller is saying, yeah, there's $5,000 worth of stuff that needs to be done to this house, so we'll drop the purchase price accordingly. Or the seller may give a credit to the buyer for the repairs. If the buyer's paying cash, that's fine. There's no approval needed by anybody. But if the buyer is getting a lender, the lender has to approve any seller-paid closing costs. So that lump sum, you're gonna have to run it by the lender and make sure that the lender will allow you to use that entire credit. If not, then what you can do is identify vendors to pay on the invoice. Say the seller is giving you $10,000 worth of closing costs and your lender says you can only use $5,000. Well, to try to capture the remaining amount that the seller has already agreed to give, then try to find the $5,000 worth of things to be done in the home and vendors that will complete those repairs. get quotes, get invoices, and have those repairs completed to use up the total amount. It's one of those things that if you don't do this and the lender doesn't approve the use of the full credit, you lose whatever you don't use. Between those two approaches, I prefer the seller paid closing costs as an attorney, provided that the lender has signed off on it. And then, of course, that the buyer understands that if there's any amount the lender doesn't approve, that they have options to try to capture the rest of that seller credit. If the buyer does not get approval from the lender for this, or if they fail to capture the entire credit, it's kind of a waste. But in terms of capturing the agreement between the parties and the intent, then I think that the seller paid closing costs is a cleaner way to go for that. This option can also lead to disputes at times, and mostly it's when the lender says you cannot use all $10,000 on as seller paid closing costs. You can only use $5,000. So the seller says, well, I want the other $5,000 back, or they say in that case, then we need to revise the contract, or buyer decides, okay, I will try to find vendors for the $5,000. The seller may say, well, I only agreed to do seller paid closing costs, and the lender said you don't have enough closing costs, so I'm not paying those vendors. Well, vendors paid on a closing statement are closing costs. So a seller can't necessarily claw back money after they've agreed to pay it. If the seller agreed to give $10,000 in closing costs and there's $10,000 in closing costs to use that towards, they can't say, well, the lender only approved $5,000, so I'm not paying you the other $5,000 anymore. We do sometimes see that as a dispute. The way that the parties can agree to seller paid closing costs in North Carolina is that due diligence repair and agreement. It kind of identifies, hey, in lieu of the seller physically making the repairs before closing, then the seller's going to give this much money to the buyer in a lump sum to be used towards buyer's closing costs. So that's how you would handle that. And what happens if the buyer moves in and finds out that the problem was worse than what they initially thought? Well, once the deed has been recorded, the transaction is done. So really your remedies after that point depend on, what did the seller know? Did the seller misrepresent anything to the buyer? Was it a material fact? There's a lot more that you need to know before I can say, well, if you find out that it was worse when you move in, then all you got to do is run to the courthouse. It is not that simple. Everything depends on what the seller knew, and if the seller had a lot more knowledge, what were they required to tell you? Sellers don't have to tell everything they know. If you're a licensed broker in North Carolina, then you are required to disclose material facts, even if your seller won't. But there are, in the residential property disclosures, there is an option to make no representation. So if the seller made no representation, then buyer, that is your indication that you need to have really good inspectors out there to make sure that you're getting a good idea of what's actually going on with the property. So if you had an inspection and you find out the property is in much worse condition than the inspection revealed, then that's almost becoming an inspector issue. It just depends on what did the seller know and what was the seller required to disclose to you. Another option, and I've alluded to it a little bit, is that the seller just makes the repairs themselves. We always encourage that buyers do walkthroughs. It's critical to do walkthroughs, but especially if you've agreed on repairs and the seller has taken on the responsibility of doing the repairs or engaging their own contractors to get the repairs done before closing. Walkthrough is going to be critical for you to determine that the repairs were made in accordance with the agreement that you made. So if the seller said that they would fix the door, but the door's still not working before you close, then that gives you an opportunity by seeing that at the walkthrough to get the seller to fix the door they said they would fix. All right, the next option is one that is kind of a last-ditch effort to help closings happen on time, but they often blow up after the fact, is escrowing money for repairs. So how they're supposed to work is, all right, buyer and seller have agreed that this repair needs to be made. Maybe it's a big repair, or maybe they just agreed on it the day of closing, and there is not necessarily a way to have the repair done before closing without delaying closing. And buyer needs to move in, seller needs to move out and get their funds so they can go buy another house. So the parties decide, we will do an escrow agreement. And you hear the term escrow all the time in real estate, but in this context, it means that a portion of the seller's proceeds, usually is where the money comes from, a portion of the seller's proceeds is set aside in the lawyer's trust account until the repairs are made. So this is going to require a separate contract between the parties. It's going to have to outline what repairs need to be made, who is actually making the repairs, what are the conditions under which the money can be released, what's the time frame for getting this done. So let's say the seller agreed to fix the door. They didn't get it done before closing. All right, we're gonna hold $500 in escrow until the seller fixes the door. Seller has to fix the door within 30 days or buyer gets the $500. So that's how it can work. Sometimes it's for much bigger projects, but that's the general idea. And where this goes sideways is if the seller doesn't get something done in time, or to buyer's satisfaction, or let's say the parties already identified a contractor that would do the work, and the contractor does the work, and then the seller just decides, no, I'm not paying anymore. I feel like you should have shopped around more and gotten a lower quote. Well, that is not usually going to work out for the seller, because in that instance, the seller has already decided that they're going to pay that amount. So you can't then force the buyer to continue to shop around to get lower and lower and lower. If you said you were going to pay $500 to fix the door, then okay, cool. If the contractor can do it for $400, great, but you can't condition your release of the money to pay the contractor on the buyer shopping and shopping and shopping until you finally get satisfied with the number. You were satisfied with the number 500. That's why you entered into that escrow agreement for $500. Unfortunately, we often see buyers and sellers get into disagreements over whether the fund should be released. And this can be a buyer saying, well, the seller didn't do this to my satisfaction, so I don't think they should get the excess money back. Or it's the seller deciding that they no longer want to pay for the repair. And if the parties cannot agree on the release of the funds, then the closing attorney that's holding the money is going to have to pay the money to the local county's clerk of court. So whatever county the property is located in has a courthouse, has a clerk of court, has a register of deeds. So that closing attorney is going to have to remove the money from their trust account and give it to the clerk of court, and the parties are going to have to institute a procedure. It's called a special proceeding, in which they file an action and they go to the clerk of court and say, I believe the money should be given to me as a seller, and the buyer says, well, I believe the money should be given to me as the buyer, and this is why. And then the clerk of court decides who gets the money. So yes, that is a court procedure, and it costs money for the parties to do it. Now, that is a simplified version of how that goes. There's notice requirements. There's all sorts of statutes that have to be followed by the closing attorney and the parties. But in general, if the parties can't agree, then you will have to go to court to decide who gets the money. So it's much more expeditious, it's much less expensive for the parties to agree to release the money and to whom, rather than having to have a court tell you who is going to get the money. So overall, if I had my way about repairs, it would be that if the parties engage in repair negotiations and the seller says they're going to do repairs, for the sake of the seller and the buyer, for goodness sakes, just do what you said you would do before closing. And then we can avoid the escrow. We can avoid the disputes over, did the contractor cost too much and maybe you didn't want to pay that much for the repair. If you agree to make the repairs, do it before closing. That is the absolute cleanest way. Now, I understand as a practicing real estate attorney, that's not always possible, but if you want to know my opinion, that's it. Get it done before closing. Let everyone have all of their obligations completed before the deed is recorded when it comes to repairs. So my number one tip for sellers, if you're going through this process, is make sure that you are actually looking at the agreement that you signed when you're making the repairs. If you agreed to replace this particular thing and then you decide in the course of replacing it that you think it's too expensive or it's actually not worth it, and you do something else, you're breaching the agreement that you signed with the buyers for that repair. So make sure you're actually holding up your end of the bargain. And my number one tip for buyers is to make sure that before you get to the closing table, you have completed another walkthrough of the home to make sure any repairs were completed the way that they were set forth in that repair agreement. All right, there is my take on the way the market is with repairs right now and how can you handle different repairs and different disputes. I'm Tiffany Weber. I am a Mooresville, North Carolina real estate attorney at Thomas & Weber. We make videos just like this to educate you on real estate law all the time. So make sure you subscribe to the channel and I'll see you in the next video.